Hello and welcome. In this lecture, we'll be exploring Rule 803 Hearsay Exceptions. In our previous video, we explored what hearsay is and what an exception or exemptions in general allow the admissibility of evidence when they are hearsay. A hearsay is a statement that is asserted for the truth of the matter being asserted. Now, in this case, the statement is being offered for its truth. And because it is being offered for that purpose, it is hearsay. However, a statement may be or may fall under an exception that in that case, although the statement is hearsay, it is admitted based on that exception. And in this lecture, we'll be exploring those exceptions. Let's start off with Rule 803, which is a present sense impression under 803.1. This is an exception to the rule of hearsay. Therefore, statements that are made under this rule are admitted. A present sense impression describes or explains an event or condition while or immediately after declaring perceiving the condition or event, and it is admissible. For example, Mary in a taxi is sexually assaulted by the taxi driver, and she managed to escape and called her husband in order to report or let her know of what's happening. This statement is, in this case, a present sense impression, and it is admissible. If Mary managed to call her husband while or immediately after the event has taken place. Number two, excited utterance. These are statements that are startling in their nature and they describe an event or a condition. And they are an exception to hearsay because the declarant is still under the stress of the excitement when they make the statement. So there's no room for fabrication once again in an excited utterance. For example, if Mary calls the police and say on the spot or a few hours later after she has, for example, been stalked by somebody and robbed, then this constitutes an excited utterance because obviously she will not lie on something like that. She will be truthful, and that will be an exception under the rule. The next the next hearsay exception is then existing condition. Now this describes in a mental state or emotional or physical condition where the declarant describes their intent, their motive, or the emotions. For example, John says, I am going to throw acid to Ben. Now, this statement manifests John's intent, what he wants to do towards Ben. Therefore, it is an exception and it is admitted. Or, for example, Jane says, I hate my husband. That statement is also admissible. Under 803, statement of memory or belief is not admissible. For example, if Jane says, I believe my spouse's extramarital affairs, it is inadmissible because it is simply a belief. It is not a fact. Under number 4, medical diagnosis or treatment are also under the exceptions. For example, statements that are made for medical diagnosis or they describe a medical history or condition. For example, John says, I have been sick since yesterday after eating at my friend's place. Number five, past recorded recollection. These are recollections regarding a matter that the witness once knew. They were created while they were fresh in the declarant's mind. They reflect knowledge. For example, the declarant, if they're unavailable or if they forget, an inventory can be used in order to describe the recorded recollection. And it is important as we talk about past recorded recollection to make a distinction between Rule 803 and Rule 12. In past recorded recollection, the witness no longer recalls all the information fully. Therefore, a, rec- therefore, a record may be read into the evidence. However, in writing to refresh recollection under 612, a witness recalls but needs refreshing. And witness in this case will testify to recall fact after remembering. So the difference between the two is that in past record recollection, a record may be read into the evidence when the declarant no longer remembers. However, in 612, a witness testifies after they have read and they have remembered the details on their diary or in their writing that refreshes their recollection. Also, business records under 803 are an exceptions if they're made by someone with knowledge, maintained regularly, and it is a record practice in the business by qualified witness that testify the record meets the requirements. There's an aspect of trustworthiness, and equally, the absence of business records can be also an admissible fact for this exception. Public records under 803 address public office activity are observed by legal enforcement officer under legal duty. However, police reports are not admissible. Findings from authorized investigation in civil case or against government in criminal case are admissible. The other exceptions are public records, absence of public records, record of religious organization, certificate of ceremonies, family records, record of documents affecting property interest, ancient documents, market and commercial publications, learned treatises, periodicals, reputation, judgments, in this case, family history and land. So these are other exceptions that apply to the same rules that the court may admit such evidence. With this, come to a close, and we'll continue with the exemptions on the next video.